Come on up, Judge Nally.
Thank you, ma'am. Good to see you.
This guy is committee chairman for Madison Forum.
Yes, ma'am.
And what's the committee name?
And the secretary of the Madison Forum.
And secretary for the Madison Forum. And you served as a judge where? Tell us about that.
Over in Pine Law, the 827 Militia District, I was a justice of the peace there. Ironically, I was appointed by the grand jury.
This guy has a lot to say about a civilized method by which we can reclaim our liberties. Very few people know the importance of the grand jury. That's the discussion tonight. We're going to film this. It will be up on our website and distributed really around the state as far as we can get it. But we're glad you're here tonight. Thank you.
Thank you, ma'am.
Welcome.
Thank you. Can you hear me in the back?
Yes, sir.
Okay.
Thank you.
Might be with me.
Oh, Macy, let's see. We're going to be running a little short of time because of the debate. I'm going to cut out some of this that I had planned to mention tonight. Basically, the history goes back to the Magna Carta, the article or paragraphs 52 and 61. And basically, the bottom line is that King John made it plain that if he or any of his justices are mentioned in there, deprived anyone of their, or any of the barons, of any of their rights or liberties, that word's in there, then the committee of 25 barons, and the barons were the knights of the realm at that time. So if you hear the comment about the committee of 25 knights, that was the first grand jury. They were charged in Magna Carta to use all of their might to see that the king did justice by his barons and his people. That's where the grand jury traces its origin back to. What a lot of you don't know, rather than refer to these notes, I'll just go from memory. What a lot of you don't understand is that a grand jury is established in the Constitution of the state of Georgia, and a trial jury are established in the Constitution of the state of Georgia. Both of them, literally, are courts of inquiry. The minute they say take their oath and sit down and start their business, that is a court. And the reason it is a court is because Article 1, Section 1, Paragraph 11 specifically states that in all criminal cases, the juries shall be the judges of the law and the facts. It's that judges of the law that we need to understand the full scope of that power. I apologize. Trying to go from memory is a little rough for me.
Oh, we all understand. Your age, we understand.
When the Constitution says that a specific group of people have the authority to judge the law, that is an exceedingly broad power. Exceedingly broad. And the reason that this is so critical and important to our particular time now is because we are faced and have been saddled with a lot of laws that were just outright bad laws. And if a grand jury says that's a bad law, it's not going to be enforced, then state legislature is going to have to do something. But where the real power comes in is where the law is turned to an instrument of plunder. And let me just try to help you understand the scope of this power. We are all familiar with some portion of the Affordable Health Care Act. We all understand that if we don't want insurance, then when it comes tax time, the Internal Revenue Service has a place on their forms where they're going to force you to put down an amount as a penalty for not having insurance. There is another provision in that statute which says that if you have insurance, but it is not to their standards of adequacy, they're going to charge you X amount of money out of your paycheck. Whether you get any more insurance or not is irrelevant to them. And by the way, you don't get any more. Of that money, that penalty and that assessment for insufficient insurance then is used to send out into the country for the stated purpose of helping those who are destitute and can't afford insurance, and Obamacare is having to help them. Here's the problem, ladies and gentlemen, and it's imperative that you understand the interconnection of laws. The Constitution, the 5th article. No property shall be taken for a public purpose without just compensation. Now somebody step forward and tell me, what just compensation does the Affordable Health Care Act provide us in exchange for the penalty they're charging us?
Zero.
Thank you. Leave it up to a lawyer to know the answer.
I didn't hear what he said.
He said zero. That statute violates the Fifth Amendment, the Article 5 of the Constitution. What am I saying? I'm sorry, I'm getting ahead of myself. Now, that's not the only thing it does. Because it just so happens that Georgia has a statute on the books, 16-8-2, theft. Theft is defined in the state of Georgia as the unlawful taking or depriving of the property of another with the intent to deprive. Property, intent to deprive, and unlawful. Here's the reason. If the statute, the Affordable Health Care Act, violates the Constitution, which means they should never have passed it. It should have died in committee because it was in violation of the Constitution. But they didn't. They went ahead and passed it. The president signed it into law. And now that law is being enforced here in Cherokee County. Well, guess what your Cherokee County grand jury can do? They can bring that the IRS director of the IRS, sit him down in the witness chair and ask him, does this piece of legislation take property in the form of money from citizens in our county and give them nothing in return? His only answer, yes.
He won't answer though.
Well, he probably won't answer, but his answer, they will find as a matter of fact and of law that yes, it does. Now here's what they do. Once they have established probable cause to believe that a crime is being committed in this county, that the instrumentality of that crime is an enactment by the United States Congress, signed by the president and enforced in this state, they can indict every congressman. I don't care if it's from the state of Washington. I don't care if he or she is from California. they can indict every one of them and the President of the United States and send them to trial in Cherokee County on felony theft charges.
It'll never happen.
Well, you're right.
That's the kind of power they've got, and you have got to get out there and help your neighbors understand the kind of power in the hands of the grand jury. When you are sworn as a grand juror, you need to understand that the power to manage your government is right there in your hands. Now, it may not be there long. Because once the politicians begin to understand, oh my God, we can't all be having our families hauled into grand juries and put down in a witness chair and forced to tell the truth or plead the fifth, which that's just as bad.
Paul,
They'll try to take that away from you.
let me add something locally.
Yes, ma'am.
That the grand jury invested the Bobo boondoggle because we pushed it and pushed it. Now, they didn't do their job, and that's why Brett Miller is laughing.
Yep.
But they brought the commissioners in and they questioned them.
Well, I also know something else about
Man,
that.
Bobo stole how many $1 million?
Here's another thing you need to know. Everybody in the state of Georgia who has a public office, a public position of any kind, I don't care if it's the governor, I don't care if it's the Speaker of the House or a legislator, I don't care if it's your U.S. congressman or U.S. senator, I don't care if it's the judges sitting down there on the Supreme Court of the state of Georgia, or for that matter, the judges of the Supreme Court of the United States, when they said Congress has the right to tax. Guess what? Georgia has another criminal statute. It's called theft by deception. Anybody with a lick of sense knows that what Congress did was took a law and turned it into a knife or a gun, whatever type of instrumentality you want to conceptualize that as, and they turned it into an instrument of plunder. The Supreme Court got into the mix, became a co-conspirator in continuing the theft in this state by calling it a tax instead of saying, no, this is an unconstitutional law that cannot be enforced. That means your grand jury can also haul them down here and charge them with theft by deception. And you say, well, this can't happen. A little old grand jury here in Cherokee County can't do that. Yes, grand jury in Cherokee County can do that. And the Cherokee County grand jury can order the sheriff to send people to Washington and bring them all back in handcuffs. If they don't want to come voluntarily, bring them back in handcuffs. Throw them in the back of a patrol car and bring them down. But so can every other county. Newton County and, where did you say you all were? Coweta. Think about it. 159 counties in the state of Georgia finding indictments against the United States, a bunch of the United, how many voted against Obamacare? A few. Yes, ma'am.
Doesn't the district attorney have to convene the grand jury?
Number one, the grand jury is, thank you. And let me just turn the rest of this into a question and answer session because I know there's a lot of things that y'all need to know. A grand jury is convened by law. A judge is commanded in the law, thou shalt convene a grand jury at this time. Title 15. Once the grand jury is sworn, at that point, that grand jury is an independent court of inquiry in the state of Georgia. Now, it may be populated like in Fulton County, it may have 17 members, judges. What do y'all have here in Cherokee? 23? Bartow has 23. 17 to 23 judges in each county.
Those are being grand jury.
Pardon?
Are you talking about total judges?
Yeah,
Superior
total.
Court, state court?
No. I'm talking about the total number of judges sitting on the grand jury court of inquiry.
Grand jury.
So it's 17 in the state of Georgia, 17 to 23. But once they are convened, they do not answer to a district attorney. They do not answer to the Superior Court judge. They tell the district attorney, bring in 3 cases, bring in 10 cases, bring in all your cases and present them. Yes, sir.
Finish, because I want to clarify something. Having been a district attorney,
Yes, sir. That's what you're doing here.
I was taught, okay, that I was in control of that grand jury. There is no statute that says that. That's a crime. I was told that I would approve who was allowed to make presentments in front of the grand jury. Frank Mills said, he never told me this. I was told that I would control what went on in the grand jury. If you read the statutes in the state of Georgia, you'll find out that the district attorney is the grand jury's legal advisor, period. He doesn't control them, he doesn't control the witnesses, he doesn't control the calendar, but every grand jury in this state is controlled by the district attorney in that county. And it's common knowledge. It's illegal, but that's the way we maintain control.
Well, that's the way the school system is run. It's not run by the school board, it's run by the superintendent.
Well, let's not get into god-awful situation with our education system, which I personally feel is responsible for everything that's happening.
Yeah.
I've been married to 2 school teachers, and I'm gonna tell you, they were both nuts.
We got a school board member here.
You got,
No, he said teachers, he said
my
teachers.
first wife, who divorced me because I couldn't stand her after 6 months of marriage, I went to Vietnam, she went home with my mommy. She married a guy who couldn't hold a job as a real estate agent. He couldn't sell life insurance. He couldn't sell investments, but guess what? He's a superintendent of schools up in
I have
North
no
Georgia.
doubt.
They gave him $400,000 a year to come be superintendent of schools up in whatever, Alaska, and they went. Right? And I'm here to tell you, not only is this guy incompetent, but he's an idiot besides. And he's controlling what goes on with your children.
Now tell us how you really feel.
Gail,
I'm sorry.
Tell us how you really feel.
Oh, hey, you don't have to ask me for a second opinion, sweetheart.
Yes,
I
Gail.
know the point that you're making is that we all need to get educated as to what our rights would be if we get chosen as a grand juror.
That's exactly
And,
right. And
And contrary to how things are operated in various counties, it sounds to me like almost every county in this state is having a problem having the district attorneys dictating to the grand jurors what they can and cannot do.
let me share with you another statute. There's a statute on the books that's, oh, excuse me, yes, sir.
Can I follow up on what she's asking? How are the grand jurors selected? Are you
That's what I'm trying to get to the bottom of.
Okay.
And how do you?
In 2012,
Grand jury.
in 2012, your legislature changed the law. If your name appears on a driver's license, if your name appears on an electric bill, anywhere your name appears on any government document, it goes down to Atlanta to an organization that handled by the clerks of the court. That organization compiles all the names sent to them, puts down the jurisdiction they're in, what county they're in. They compile a list annually and send it to the clerk of the Superior Court. The clerk of the Superior Court has a piece of software where they go push some keys and up pops a list. In Bartow County, you'll get a list of 50 to 53 names chosen at random. There's 2 numbers to the left of the names, and one of the numbers is your particular number. The other number is the number in which you were drawn. In Bartow County, if you get a hold of that list and you look at it, if you look down there for your name and you're number 10, you're going on the grand jury. If you're number 23, you're going on the grand jury. If somebody didn't show up for whatever reason and you're number 24, you're going on the grand jury.
So is this public information that we could go to our?
It is public, oh, God bless you for bringing that. Let me give you a little clue here about what you might run into. If you've got a corrupted clerk, and I'm not saying your clerk has to be corrupt, but when I say corrupted, I mean the county attorney has gone in and lied to your clerk and told the clerk, don't give out the list of grand jurors that have been chosen for this next term. If they say, don't give out the list with home addresses or phone numbers, just give out the list of the names, they're lying to you.
And that's what I've tried to get names and addresses in Cherokee County,
And
and they'll only give you names.
The law in the state of Georgia right now is the information about grand juror pools is not, and here's the language, is not required to be made public. It doesn't say it'll be kept secret. It says is not required. And there's another statute which does require them to reveal the names to a defense counsel. So you have a right to know who your grand jurors are, and if your clerk tells you that you can't know who the grand jurors are, they're lying to you. And here's the great thing. If you record it, if you record that conversation, you now have evidence that your clerk has just committed theft by deception.
Yeah,
You can charge.
I don't think so. Her question was, do you have to tell them you're recording?
No, you do not. There's a 1983 Supreme Court of the United States decision, and this is the one thing that really irked me back about the Monica Lewinsky shindig, where the lady was charged in Maryland with certain
conversations.
Yeah. And there was a 1983 Supreme Court of the United States decision which held that an individual, one, did not have to report that they were recording their own conversation, and number two, it was introducible in evidence because it was more reliable than notes taken after the conversation. So any conversation you are a part of, you can record, and it is usable as evidence. Yes, sir.
What constitutes interference with a grand jury?
Glad you asked. Glad you asked. That you do need to understand that.
Let me answer. Let me answer.
All right. Yeah, you take that one on.
I don't
What
want
constitutes
him, I
interference?
don't want him to respond. We may have to hear about his second wife.
Okay, I'll control him.
But the fact of the matter is that it's a matter of discretion of the district attorney. So if you have any contact whatsoever with any member of the grand jury, and you have a constitutional right, by the way, to contact that foreman, but in Cherokee County, if you have any contact whatsoever with any member of the grand jury, you are going to get indicted for interference with the grand jury. Now, whether or not you're guilty of that crime is an entirely different matter. The point is to stop you from trying to contact the grand jury.
Now that's the best answer right there, and I hope every one of you understand what he just said.
But is that?
You have every
No.
right to contact the foreman or any other juror. As a matter of fact, there is case law on point. And by the way, let me tell you, there's two cases in the state of Georgia. One's from 1878 and the other's from 1953 in Liberty County. And let me just, what time? How much time have I
You got all
You
night.
have plenty of time. You
Keep
got
talking.
20 minutes.
you really need to understand these two cases because they are seminal to our right. The first had to do with a mayor down in Chatham County in Savannah. The grand jury subpoenaed all of his records. They wanted them all just because they had heard a rumor. Now, the one thing a grand jury can't do is to violate, and this is the words from the United States Supreme Court, a grand jury itself may not violate a valid privilege, whether established in the Constitution, in the statutes, or in the common law. That's the only thing a grand jury can't do.
Did you say valid privilege?
Valid.
Valid.
Husband-wife privilege, doctor-patient privilege, attorney-client privilege.
That's the only thing a grand jury can't do. Grand jurors can go through, they can go through every public office in the state. In our Constitution, it specifically states that if the governor, the lieutenant governor, a legislator are indicted for a felony by a grand jury, well, guess what? A grand jury can go look at the governor's office. It goes on further and it says when it comes down in Article 6, talking about our Supreme Court talking about our judges, the judicial power of this state. Judges may be removed or disciplined. And then it has a very specific provision. Any judge indicted for a felony by a grand jury, the district attorney shall. Now I'm going to tell you something. I got to stop here now and tell you about Smith v. Baptiste. In Smith v. Baptiste in 2010, your Supreme Court justices, who are sitting now with one exception, he retired, held that you do not have a right to the courts.
Seems to be unconstitutional.
It doesn't.
Federal Supreme Court.
Your Supreme Court justices,
Georgia Supreme Court.
Georgia Supreme Court justices said you don't have a right to the courts.
Smith.
Yet, official code of Georgia, 1, and you go write this down and look it up, 1-2-6, paragraph 6 and 7. That law says that every citizen shall enjoy their rights completely, and it lists them. Number 6, right to the court. Number 7, right to testify. And that bunch of jesters sitting down there in black robes didn't even bother addressing the code of the state of Georgia. They did not bother addressing the phrase in Article 1, Section 1, paragraph 12, which says that you have a right to prosecute or defend your own cause in any court of the state. If you've got a right to prosecute or you've got a right to defend, by God, you have got a right to the court. But they ignore that kind of logic. They go off on a tangent.
Has it
And
been
like
challenged?
with his executive order,
Has that been challenged?
disobeying the
No.
law.
No, they didn't appeal it. They paid, and you know why they rule that way? You're going to love this. You, young lady, are going to love this. Because the judge in the lower case in Fulton County told the prevailing attorneys that they could not collect attorney fees from the defendant. And he said because it would impair the rights of citizens to petition the courts. And the lawyer jumps up, oh no, they don't have a right to the courts. The judge said, well, when I come up, yeah, citizens got it. So he goes and appeals, and guess what? The Supreme Court ruled that they didn't have a right to the courts just so the lawyers could collect their 30 pieces of silver.
That's the way it works.
Yes, sir.
I'd like to know what oversight there is to control the Supreme Court judges.
Go look in the mirror.
No, I understand that, but, you know, when they make their own rules and they're the highest court in the state,
That's
The
what
rules
you
of
know, somebody
rules-
has to have the power of oversight.
the rules of practice and procedure are set in law. And remember what I said about a grand jury. They judge the law. There's a case right now in Cherokee County where a judge can very quickly be looking at an indictment by a Cherokee County grand jury. Why? Because the law says that when a party is served notice that
Verification, what do you want me to say?
thank you, verification. That a verification must be filed within 10 days of being notified of its requirement by the opposing counsel. And if it is not submitted within that 10 days, their pleading shall, the word is shall, in the law, shall be struck. The judge ignored the law, did not strike the plaintiff's pleadings. He violated his official oath of office, number one. Number two, he committed an act of theft. That judge right now could be looking at 10 years in a state penitentiary if a Cherokee County grand jury, is there anyone here on the present grand jury in Cherokee County?
No, they're all Republicans.
If you know a grand juror, you need to bring this to their attention. This judge needs to go. He needs to go right now because he is an unindicted felon. He is a thief in a black robe.
He's also an idiot. But
He's an idiot. That's beside the point. Now, who's got the power? The grand jury has the power to judge the law and the facts. You may take this case to a grand jury, and it's entirely possible that you could have a grand jury look at that 911.11.1 statute and say, well, we don't read it the same way, so we're not going to indict. That can happen. But just getting the case to the grand jury, I mean, you're going to have soiled drawers all the way from Cherokee County down to St. Mary's Island.
only the laundryman will know how to say it.
Yes, sir.
It's my recollection, I don't have it in front of me here, but it's my recollection in the Constitution of the State of Georgia that it states clearly that the judge is the judge of the law. So how do you reconcile that tension?
No, sir.
No.
No, sir. Believe it or not, and I thank you for bringing that up. I thank you for bringing that up. The phrase, shall be judges of the law, that occurs one time in Article 1, Section 1, Paragraph 11. In criminal cases, the juries. It is not found in the judges. It is not found in the legislative court. It is not found in the governor's office.
Constitution of the State of Georgia actually says that the jurors shall be the judges of the law and the facts, which is the basis of jury nullification. Because if the jurors decide that the law is inapplicable in this state, then they can dismiss the case. So I've actually been held in contempt by Frank Mills, spent 24 hours in jail, paid a $100 fine, because I told the jury that they were, in my final arguments, that they were the judges of the law and the facts. The judge shut me down, despite the fact I'm quoting the Constitution. When I repeated it, he gave me a $100 fine, 24 hours in jail. He won't send me to jail anymore because I filed 11 habeas corpus petitions for the inmates that were there. So it's no Perry Mason trick. If you listen, I appreciate all you people, and I really, really appreciate the fact that you want to proceed with this securing of your rights through political means. But the fact is, no matter how many times you win at this level, they're going to screw you over at the next level. Thomas Jefferson told us that a little revolution now and then is a good thing. We got that going on right now. But College, Canton, University of Missouri, they all just went berserk. Now, I'm not saying that they were right, but the fact of the matter is, that kind of thing is gonna happen more and more and more if our country continues, our government continues to ignore the law and ignore the rights and the wishes of the population.
Here, here.
Okay, hold on just a minute, do you still have a question? Davis?
No.
You had your hand up, okay. To you.
I'm just gonna ask this question, make a suggestion.
Yes, sir.
Could those of you that know all this detailed information get together, make maybe 4 30-minute segments on YouTube and let us watch them and learn and spend about 2 hours in detail going into these different things, explaining what the citizens have the power to do, so that we can watch them and share them with people?
Well, we would,
1,000 what ifs and 1,000 contingencies, so
Now-
to sum it up in 3 minutes would be very.
Just-
That's what we're talking about. But
Just so-
4 30-minute segments, so you got 2 hours, but somebody can sit down and watch it for 30 minutes.
just so you know, this is being recorded, so everything, that's said here tonight, will this be posted on the, Madison?
Madison Forum Chairman.
This is being recorded tonight, and we will be able to watch it, but what he is asking for is what I'm asking for. We need a training manual and training video clips, so that we can take this show on the road.
Yes, you're right, you do need to, but keep in mind, the only thing you need to know, really, is one, you have a right to talk to a grand juror or the grand jury foreman. And if you can't get to them to talk to them, then send them a written letter, or you can draw up a formal petition, formal looking court petition, and get that to them. You have that right. Anybody who obstructs you in your right to contact the grand jury on a matter that's within the jurisdiction of the grand jury, they are thieves, they are traitors, they need to go to jail. Yes, ma'am.
Okay, so like say a grand jury is sitting and you have information, me, I'm not sitting, I'm a private citizen. I have the right to write to that foreman and suggest that the grand jury go in a direction.
Yes. You can tell them, look, I've got information of a felony that was, a felony, let me think, that a crime was committed over at Joe's Barber Shop on the 13th, and I'd like to give you the evidence. They've got to hear you. Their oath of office. Well, bear with me. I've got
If it's
this I've got
uninvited,
to
then
read.
don't have to hear it. If it's uninvited. But, and getting before the grand jury as a civilian, in this state, you're gonna have to go to the district attorney's office and ask for permission. Now, that's not the law, but that's what's gonna happen in this state. And as soon as you tell the DA, well, I wanna complain about this, or I wanna get an indictment against the judge, he's gonna say, no, you can't go before the judge. So,
And may I add to that and tell you that at the last hearing, what was brought up was my attorney, Channing Russell, reported crimes of theft by Gary Moss, by Judge David Canton himself, and several other prominent figures in the county. He reported it to them. He gave it to the district attorney. She said, I can't investigate it because Gary Moss is my former boss. He took it to the sheriff's department and they said, well, we're not going to investigate it. So he took it places and they said, no, we're not going to do that. Why? Because the end of the sentence that they don't say is we're going to protect the ruling elitists in this county. That's what he was saying.
Here's the oath of a grand jury. The following oath shall be administered to the foreman and each member of the grand jury. You, of the grand jury of the county of Cobb, whatever, shall diligently inquire and true presentment make of all such matters and things as shall be given you in the court's charge, or shall come to your knowledge touching the present service. Diligently inquire and true presentment make of all such matters not some of them. Not a theft, not just a theft by some poor kid down here in the slum, but a theft against a judge. Because the Constitution says judges can be found probable cause to be charged with a felony by a grand jury. Yes, sir.
In addition to this, there are other things that you can do. I mean, we don't have to start a revolution today, but don't forget Thomas Jefferson. There's a movement that started on Facebook. It's called defund, that's all in caps, government, exclamation point. And people say, how do you defund government? What's going on? Stop paying your taxes. You know, we did that in the Vietnam War. We quit paying the federal portion of their phone tax. Remember that? Nobody lost a phone, nobody went to jail. The fact of the matter is, in the United States of America, you are required by law to file your income taxes on April 15th. You are not required to pay them a nickel. All you're required to do by law is file. So if you use your head, okay, divest yourself of your ownership of things. I don't own my farm, my children do. I don't own my cars, my wife does. I haven't paid taxes since 2000 when they pissed me off. I owe $150,000 right now. They've called me once. They don't show up at my house, they didn't show up at my office because I don't own anything.
How can they charge you interest then?
I'm sorry?
How can they charge you interest if you don't pay?
They didn't charge me interest, I'm not gonna pay that either. But the actual tax that I owe them was $23,000. It's now up to $150,000 because of interest and penalty. It doesn't matter to me. I'm not gonna pay a nickel of it. And because I don't own anything, I don't have a job that they can garnish, I work for myself when I work, which was very infrequently. But be that as it may, there's nothing they can garnish. There's no property they can take away from me. And if people, I'm sorry? No, sure, no.
We know we have 5 minutes left to give that to the judge.
I should.
5 minutes left, whatever you want to say, what are you going to allow for questions?
Well, we've been pretty lively with questions. Is there any? Oh, I'm sorry. I forgot to give you a case, and I need to do this. The case from 1878 was Henry Lester. In that, Justice Hall made the comment, any citizen or person of lawful age may prosecute for offenses against the state. How do you feel right now knowing that you just found out that you're now a district attorney? You are.
Where do I start?
You are a district attorney. You stand in the place of a state's prosecutor when you go before the grand jury. Now, does that mean that you're going to prosecute it from the criminal case you bring to the grand jury? Does that mean that you've got to go to the trial court and handle the trial? Does it mean you have to go up with the case on appeal? No, it doesn't. Only thing you have to do to stand in the place of your district attorney before the grand jury is give them the evidence. That's it. Just give them the evidence. And that's what a district attorney does. That's it in a nutshell. Well, not really. A lot of them lie to the grand juries, but they do it with such finesse, grand juries don't understand what's going on. But anyway, that's Henry Lester. And the other case was Cook v. Sykes, 1953, from down in Liberty County. A citizens committee, 3 men, got tired of their sheriff not doing his job. They went and hired a lawyer. The lawyer went into the grand, and they told the lawyer, go into the grand jury, we want to present our evidence. The lawyer stepped into the grand jury's room, presented the case just as if a district attorney would have, called these 3 men as their witnesses. Governor Talmadge had to fire the sheriff. They got rid of the sheriff. Now, that's another thing that the grand jury can do. It has choices. In that case, they didn't have to send an order to the governor of the state of Georgia to fire their sheriff. They didn't have to do that. They could have found that sheriff guilty of a 5-year failure to comply with his official oath of office and sent him to prison.
No, he'd have to go have a pedicure trial first.
Wait, they could have sent him to a trial, which that in turn would have probably sent him to jail. He could have been looking at 5 years. But the grand jury doesn't have to send everybody to trial. There are other things that a grand jury can do. So anyway, I thank you, ladies and gentlemen. If you have any.
Is there one more question that you missed?
Oh, if there's a trial, if somebody is demanding a trial by jury, do they have to prove that there was a criminal, that there was a crime before that? I mean, because isn't it a crime?
Normally-
In a criminal court?
Normally, if you're talking about, okay, there are not most, but a lot of felonies have to be presented to the grand jury for a finding of probable cause. Other felonies and misdemeanors are usually tried through indictments, through information. That does not have to be the case. A grand jury has the authority to indict for a misdemeanor if they want to. But it just takes a lot of work off of them to allow some things to go to the court. Yeah.
Probable cause determination is your right as a citizen, guaranteed to you in the federal constitution, right? If you are arrested for any crime, federal law says that you must be brought before an independent magistrate within 72 hours for a determination of probable cause as to whether or not you will stay incarcerated, okay? When I was an assistant district attorney, right here in this county, I put those things off 3, 4, 5 weeks, not 72 hours. And unless the defendant had a worthwhile attorney, I got away with it. Okay, I was instructed to do that by my boss, Frank Mills. Right? But the fact of the matter is, getting out of law school, I didn't know any law. And it wasn't until Paul Nally got mad at me and wanted to arrest me one night that I even bothered to realize that I didn't know any law. Paul, when I had a research project that I had to do you think I go down to the law library? Hell no, I call him on the phone. I mean, he knows it.
Is there a constitutional right to a speedy trial?
Constitutional right to a speedy trial only occurs with certain preemptive things. It's not necessarily, it's not like the right to a trial per se, but you do have a right to a probable cause determination. And they can avoid giving you that pre-arrest hearing in front of a magistrate if they indict you. And so that's why the whole indictment process.
If I can interject one other thing that's not really related here, but the case, the U.S. Supreme Court case from 1975, Grinstein v. Pugh, the Supreme Court, and I'm going to state this a little differently than lawyers would be normally hearing it, the Supreme Court actually ordered every state in the nation create whatever statutes you want to take care of getting people into the justice system for prosecution, but you will, before they are arrested, give them a probable cause hearing before a judicial magistrate, or if they are arrested first, you will provide them immediate access to a probable cause judge right after the arrest. Immediately.
If you demand it.
No, it doesn't even have, you don't even, that case, you don't even have to do
But
it.
if you don't demand it, they're gonna let you rot in that jail cell.
Now, they will let you
If your
rot.
attorney doesn't say, my client's right in the jail cell, you're not ever gonna get yourself heard.
But if you're not heard in the state of Georgia within 72 hours, they gotta go and turn that key and let you out.
Yeah, if you have a good joy, you'll get out. But there, look,
Okay,
Thank you.
I want to interrupt at this point and just say this, that we have seen the grand jury, the local grand jury, in practice in Cherokee County over the boondoggle case, the Bobo boondoggle case that the people brought and insisted be heard. We pushed it and pushed it and pushed it. And finally, Monty Boris's husband put a letter together, took it to the grand jury foreman. It was heard by 3 grand juries before it was deep-sixed and, quite frankly, by the district attorney.
And if I may interject,
And that district attorney was Shannon Wallace. And I'm going to name names because you need to know who are the enemies in the county.
I will tell you this, that I was told by the grand jury foreman. They wanted the committee who was doing that investigation, told the district attorney, we want these other witnesses we want to hear from. The district attorney said, you've already heard everything you need.
So Lois Lerner.
That's all right, we want to hear. That turned into a tit for tat. Finally, in frustration, the district attorney looked across the table to the foreman and said, do you want me to take you back down there to the judge so he can remind you of his charge? That district attorney right then committed the felony act of embracery, 16-10-91. A felony, intimidation of a grand jury, obstruction of justice. Why is that woman not sitting in a female penitentiary in the state of Georgia today?
Because all of our cronies are up there in the.
Do you know that the Tea Party in Canton and also Woodstock endorsed voting for Sharon Douglas to be the district attorney?
You make mistakes.
Yeah, we did.
But when you make a mistake, get them out of office and put them where they belong.
But you make the mistakes because you believe the lies.
Right, exactly.
And the fact is that as long as the.
It's okay.
Get me wound up.
I don't want to push him off the stage. Here's what I want to do.
Are we gonna do 2 more, one in January, one in February?
Yes, we are going to have a second meeting in January. This will be about jury nullification. I believe that date is January 9th, but it's the second Tuesday.
Yeah.
You don't want to miss the second meeting. Then the third one will be February 9th, I believe. That will be a panel discussion that will include Judge Nally, maybe Mr. Brett Miller. There probably will be several others that will ask to sit on the panel, and we'll each give them a chance to give a 10-minute presentation and then open the floor to questions. All of this is going to be filmed and logged so anyone can go back and listen and review and listen. I've asked the judge to put together a syllabus with an outline of the different things that have been said and the laws that you can go and research yourself. We need to start bringing pressure on our district attorneys to uphold the law.
Or boot them out of office.
Or boot them out of office. Here's the problem. The problem is, look in the mirror. We are allowing this to happen. We fail to know what the laws are, and we don't execute them. And I keep saying, the grand jury process is a civilized process by which we may reobtain our liberties. It's up to us to do it.
But education.
Well, yes, we've got to understand the process. It's absolutely an education process, and then we can execute it. So obtaining liberties is about being an educated citizen, and we need to hold more of these symposiums all over the state. Question?
No, if the DA has eye behind his name, vote against him.
If the DA has an eye behind the name?
Because-
Oh, I got you. Okay, now I